You are attending the seminar CLE for Here, There, and Everywhere. Where is and what should you do with data? First, we've got some housekeeping items. This presentation is being recorded. The video will be edited and posted on our SKO YouTube channel. By the way, by law, we have to announce that, or I guess at least by the law of YouTube. Following this webinar, all participants will receive an email from Renee Lamb of our office, and the email will include the Kentucky and Indiana activity numbers to claim CLE credit. The email will also include a link to a survey on SurveyMonkey. Please complete the survey to help us make any changes we might need to improve. During the presentation, there will be a poll to respond to. Please participate as it is required for CLE credit. Well, at least I think that's an Indiana thing. All right. All right, let's start out. The privacy of individuals and data collection have been part of the legal dialogue for much of the U.S. history. Ran across something in the late 19th century, long before internet, social media, and big data collection. There was an article in the Harvard Law Review written by Samuel Warren and Louis Brandeis, voicing concerns that technological advances like instantaneous photographs and the newspaper enterprise might make good the prediction that what is whispered within closed doors will be proclaimed from the housetops. That's actually a quote from the Bible, Luke 12:3. They argued for a common law tort based on an individual's right to privacy, which has been taken in a lot of different directions. Since then, and even more recently, the U.S. and the world have been struggling with how to balance an individual's right to your privacy rights with technological innovations in the information age, resulting in somewhat overwhelming activity around new laws and regulatory enforcement with resulting compliance requirements and risk of liabilities to businesses. Data can be so useful for a business, but it can also be risky to have it if it is of the sensitive nature. Businesses must manage risks relating to unauthorized collection, use, disclosure, transfer, modification, and destruction of information through physical, procedural, and technical security measures. Ultimately, businesses have to be aware of and know where is the data that they have, both digitally and physically. It's still protected data, even if it is in a file cabinet somewhere in a hard copy. How is the data collected? How is it being stored? Is it secure? How is it being secured? And how is this data being disclosed or shared or transferred to other people? Every business has data to be protected. Even a small business has, employee data, assuming they have employees. And then often there's customer data and related items. Ultimately, in addition to knowing the answers to those questions about, where, how you have data, a primary way is to minimize risk, is to minimize data collection. Don't collect what you don't need and get rid of anything you no longer need. Having data to which you are not entitled or disclosing or having it disclosed inadvertently can bring about significant expense. As H.G. Wells wrote in 1920, human history becomes more and more a race between education and catastrophe. Even recently with all of the things going around the pandemic and COVID, businesses are collecting more data than they used to collect about their employees, such as vaccination status and some health status. This presentation is organized around 3 questions to highlight compliance and risk minimization. The first is, what are some of the laws and regulations that might apply to your data collection, retention, and use? What are some of the policies and practices to have in place to govern your data collection, maintenance, and use? what type of analysis should occur in connection with vendor contracts, and what provisions might be appropriate to include in the contract. A little button, there it goes. What are some of the laws and the regulations that might apply to your data collection, retention, and use? The materials that you have, it's PowerPoint that's part of this presentation, lists some of the federal laws that apply to data collection, retention, and use. These include broad consumer protection laws such as the Federal Trade Commission Act. There are also laws applying to particular sectors like financial institutions and health care industry, as well as many apply to activities that might use personal information. One of the things that I think people don't think about too much and that applies to everybody is the Federal Trade Commission. They've been acting in enforcement using its mandate to prohibit unfair, deceptive consumer practices to apply in the collection, use, processing, protection, and disclosure of personal information. I believe they troll around part of the time and check websites and see if people are following their privacy policy that's posted on their websites. Recently, and in mid-September of 2021, the FTC voted to approve a series of resolutions directed at key enforcement areas, including the following: children under 18. Harmful conduct directed at children under 18 has been a source of significant public concern. Now the FTC staff will similarly be able to expeditiously investigate any allegations in that area. Another area that they've passed this as a key enforcement area is algorithmic and biometric biases. This allows the staff to investigate allegations of bias in algorithms and biometrics. There's been a lot of talk recently about how facial recognition has innate bias in it, as well as other things. The third area that there is going to be a key enforcement area is deceptive and manipulative conduct on the internet. This includes the manipulation of user interfaces, including dark patterns. And I hadn't really thought about the term dark patterns, but dark patterns is what the FTC is using to name techniques which impair consumers' autonomy and create traps for online shoppers. The practice of dark patterns affects online consumers in ways that tend to seem benign. For example, a shopper contemplating items in their cart may be pressured to complete the sale if they receive a notification such as, hurry, 3 other people have this in their cart. And that is, the FTC is considering that to be a deceptive practice. Also, another area in this dark patterns that they're looking at is online consumers who wish to unsubscribe to newsletters or email blasts. Sometimes to get to the unsubscription, you have to click through multiple pages, and there's not an easy to find unsubscribe button. That is something that the FTC is also looking into, and they're not alone in looking into that. In March 2021, California's Attorney General announced regulations that ban dark patterns and require disclosure to consumers of the right to opt out of the sale of personal information collected through online cookies. As I am sure you're probably aware, California has been very proactive and has enacted one of the most comprehensive data protection and security laws in the nation. The new regulations also prohibit companies from requiring consumers who wish to opt out to click through numerous screens before achieving their goals. Litigation in this area has been prevalent. For example, fairly recently, the weight loss app Noom is facing a class action alleging deceptive acts through Noom's cancellation policy, automatic renewal schemes, and marketing to consumers. The class action survived Noom's attempt to get it dismissed in August of 2021. The approval of this series of resolutions will enable the FTC to, as they stated, efficiently and expeditiously investigate conduct in core priority areas. They have directed that all compulsory processes available to it be used in connection with the enforcement of the Children's Online Privacy Protection Act. This mobilizes the full force of the FTC for the next 10 years and gives the FTC staff full authority to conduct investigations and commence enforcement actions in pursuit of the goal. The FTC has offered very little elaboration as to how it will use this such compulsory processes, which could include subpoenas, civil investigative demands, and other demands for documents or testimony. Note, though, that the initial investigations that the FTC likely makes usually involves, visiting a business's online locations and websites. So, it's not obvious that the business is being investigated initially. In addition to the FTC enforcement emphasis, new cybersecurity guidelines have been put in place for federal agencies, which will likely affect anyone that contracts with the government. These came through the fiscal year 2021-2022 guidance on federal information security and privacy management requirements. Rolls right off the tongue, doesn't it? For federal agencies. And it was put in place by the Office of Management and Budget in December of 2021. The guideline is based on 4 principles. Agencies, these are the federal agencies, are directed to adopt zero trust architecture, which is policies and procedures that assume technology will fail or bad actors are attempting to access the system, i.e. no trust whatsoever. Agencies are to move away from self-attestation testing, that's a little tongue twister, that is testing that is only verified by the party being tested. They want use of third parties to test systems for vulnerabilities. Assessments are to move toward a risk-based analysis, that is weighing the risks involved with the data processing and the sensitivity of the information against the benefits of processing the data and controls in place. Again, this is, in essence, basic risk management. And last, agencies are to use automation in their reporting and incident management. And then there are the, let's see now, up on the screen are some of the laws that, federal laws applying to personal information. And then there are state laws, and state laws vary as to what is covered in the application. Some states have more comprehensive laws, such as California. Some states, like Illinois, have additional protections that apply to biometric data, which Kentucky may be joining before too long. All states have enacted laws that require those collecting, using, or managing personal information to notify affected individuals, and in some case, regulators, the media, and others if a data breach occurs. A smaller but growing group of states require organizations to take proactive data security measures to protect personal information from unauthorized acquisition, use, or disclosure. State data security laws typically fall into one or more of several categories. Let's see. General laws that require organizations to take broadly stated reasonable data security measures to protect personal information. Prescriptive laws that require organizations to develop, implement, and maintain specific data security measures, and in some cases, a comprehensive information security. And incentive laws that provide an affirmative defense against certain claims or other relief to organizations that implement and comply with reasonable written information securities. It's somewhat like state securities laws in that state data protection laws apply to protect their residents. So sometimes a business falls into coming with under them just by dealing with a residence of the state. Let's see, these laws have broad ramifications that may not be obvious. For instance, many newer or newly updated residential buildings utilize smart access systems to identify and grant access to residents and guests based on their biometric identifiers, like fingerprints or facial recognition, or their possession of a key card or fob. Companies must be mindful of the data privacy and security related concerns that arise in the jurisdictions where these properties are located. Excuse me. New York has passed the Tenant Data Privacy Act, imposing rigorous data privacy and security obligations on the owners of smart access buildings. Additionally, a growing number of jurisdictions have laws regulating the collection and use of biometric information. For instance, Portland, Oregon, and Baltimore County have passed laws banning the use of facial recognition technology. Further, a number of states, including California, Illinois, New York, Texas, and Washington, regulate the collection and use of biometric information more broadly. And it's kind of I guess some of the applications of these biometric laws are not things you would necessarily think of. For example, an action has been filed under the Illinois biometric privacy law relating to AI-powered vehicle cameras. Biometric information also qualifies as personally identifiable information under the data breach notification and reasonable safeguard laws in many states. There's also state laws outside of the U.S. can apply to laws in the U.S. There's a list of some of the things on the slide. The one that has made the most splash is the General Data Protection Regulation that was put in place by the European Union. California's laws have many of similar obligations as the GDPR, excuse me. Canada has Personal Information and Electric Documents Act. And then there are some places like Russia and a few others that require any personal data of the individuals, of Russian individuals, to only be maintained within and stored in Russia. It's kind of the let's get some business here laws. What's in store for 2022? Certainly, with respect to the laws, we expect more turmoil. Federal legislation continues to be in play, but there do not seem to be any front runners at the moment among the various bills that have been introduced thus far. Numerous states have legislation that did not pass in 2021, but will carry over to 2022. And some of those bills are a significant departure from what currently exists and would not be considered industry friendly. In the absence of a federal law that preempts state privacy laws, it is likely that many of these state measures will be enacted. In addition, the newly established California Privacy Protection Agency will engage in rulemaking related to the California Privacy Rights Act of 2020, which amends the CCPA. Already during early January, Kentucky, Maryland, Oklahoma, Vermont, and Florida have introduced privacy legislation. Kentucky introduced two bills, House Bill 32, which is a new biometric privacy bill, requiring businesses to obtain prior written consent from individuals and provide them with notice relating to the purpose and length of collection, storage, and use of their biometric information. Second bill, House Bill 75, the Protecting DNA Privacy Act, which would restrict DNA testing to situations in which the subject has given express consent. However, there are going to be certain exceptions to that, such as criminal investigations. On a helpful front, Utah joined Ohio to become the second state to enact a legislation creating an affirmative defense to certain causes of action arising out of a cybersecurity breach. Though not identical, both Utah's Cybersecurity Affirmative Defense Act and Ohio's Data Protection Act primarily underscore the importance for organizations to be proactive in assessing cybersecurity risk and to then adequately address those risks. Many of us lawyers that work in this area have believed for some time that there is a defense that a business can use when it has taken reasonable action to protect individuals' personal data in compliance with industry standards. It is not possible for any business or anyone to provide an absolute safety guarantee, but being attentive with policies and procedures in effect to minimize and protect personal information may prevent liability in the event of breach. If you remember, for the most part, Equifax's liability in its breach turned down the fact that it failed to timely implement software updates, which, if they had implemented, might have provided protection. So, if you don't pay attention, you can get in big trouble. The second piece of the talk is what are some of the policies and practices to have in place to govern your data collection, retention, and use. In looking at all of the laws and regulations, it's helpful to try and find the commonalities as opposed to the differences, to try and implement efficient, cost-effective, and meaningful ways of dealing with a constantly shifting regulatory scheme. One of the common elements among the California, Virginia, and Colorado laws, as well as the GDPR, which is the European Union law, and many pending proposals is data minimization, which results in risk minimization. As I kind of mentioned before, data minimization, it's a hard word to say, is a theme of the policies and practices that should be implemented, and it consists of basically two strategies. Only collect the data that is actually needed in your business, and don't keep data any longer than is needed. The less you have, the less risk. The Colorado Privacy Act presents it succinctly. It's saying a controller's collection of personal data must be adequate, relevant, and limited to what is reasonably necessary in relation to the specified purposes for which the data are processed. Virginia's Consumer Data Protection Act has similar statement. A controller shall, 1, limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to the purposes for which such data is processed and is disclosed to the consumer. The California Privacy Rights Act amends existing California law to bar businesses from collecting more personal information than reasonably necessary and proportionate to achieve the purposes for which the personal information was collected or processed, and requires that a business shall not retain a consumer's personal information or sensitive personal information for longer than is reasonably necessary for the purpose for which it was collected. I was talking about data minimization. The part of the deal in that is not only does it make it easier to secure the data if you have less of it, in the event of a breach, it may give you an affirmative defense that you have tried to keep your data small, and data breaches costs often relate to the number of records that are disclosed in a breach. So the fewer records, the less the cost. A business can address data minimization using simple, straightforward steps. Some of these are identify the purpose for which the business needs to collect personal information, whether it be providing goods or services, advertising information relating to employees or other functions. Identify the minimum amount of information that is necessary to achieve the business purpose. Identify the amount of time the business needs to retain the information. identify the amount of time that the information needs to be retained, designate and control the parties both within the business and outside, such as vendors that need access to the information to achieve the identified business purposes, and disclose to the person to whom the information relates the purpose for collection, who will have access to the information and how long it will be held. It's also important to document this process, and that would be a data inventory of the categories of personal data collected, the category of data subjects from whom data is collected, the purposes for the collection, the category of recipients, and the applicable retention periods. List the systems, digital and physical, or applications on which personal information is collected, and determine whether the systems or applications are maintained internally or externally. Appoint an owner of the system with periodic updating of the inventory. Information security programs include various program elements. I think that was on there. We go. Policies, safeguards, training, vendor governance, monitoring and review, incident response. I'm going to discuss some of those aspects of those elements now, and when we might go back to it at the end. The first is policies that should be in place. Include data maps, which is what data is collected and where is it digitally and physically. Don't forget the data in paper format. Then a data protection impact assessment. This is the risk analysis to help identify and minimize risks associated with data collection. Not all data needs the same amount of protection. Some is more sensitive than others. That's part of what this impact assessment is doing. The next generation of privacy laws require covered entities to perform data protection impact assessments in some cases. And those will be effective in 2023 in California, Colorado, and Virginia. Written information security policy. This would include administrative, technical, and physical elements. And also something that is happening a lot, many customers require that their vendors have and provide a copy of their information security policy, especially in IT-related contracts. Then we have privacy policies. These govern the use of personal information by a business and is typically published for customers and users of a website to see. Note that it is often a good idea to have the privacy policy cover not only the collection of information from a website, but also information is collected in other manners, including in person, physical location, or, for example, at a trade show. Otherwise, I suspect most businesses at some point merge this information together, information collected physically as well as information collected digitally. And so you would want it to all be under the same policy. The privacy policies need to be tailored to reflect what a business is actually doing and what it expects to do or might do in the future. Part of what the FTC looks at when they look at different websites is to see what the privacy policies are and are they, is the business following the privacy policy that they've put out there. Information is subject to the privacy policy in place at the time the information is collected. And so a later amendment to broaden the scope or use or collection of information would not apply to information collected prior to the amendment. So your privacy policy needs to be broad enough to cover what you think might happen. Otherwise, it's kind of a nightmare to think about having part of the data you collected be used, part of it be under one privacy policy and the rest of it under something more liberal. The only way to get that older information under the older policy under the same terms is to get some kind of consent or some kind of disclosure again of the information after and under the new policy. And for an example, of something that you always would want to include in the privacy policy, even if it's something that's not currently on the horizon. The privacy policy should almost always include the disclosure in some case, an ability to disclose, in some case, transfer the information to a third party in the connection with the sale of a business or a division of a business. Also note that in some states like California, there are additional requirements about personal information that is the subject of a sale. One other item of the policies was the terms and conditions. They're usually also on a website, and although they are not necessarily directly about data privacy, they're often the document that contains rules about dispute resolution and limitation on liability, which is nice to have. It may not be absolutely enforceable, but if you don't have it up there, you have nothing to claim about. Safeguards. Note that federal and local laws may call for the implementation and maintenance of safeguards. Safeguards like policies should be constructed to match the business and its practices. They should also be tailored to the risk level of the data, which is determined in connection with an assessment. There's no reason, and it is not cost effective, to spend the resources on high security when it is not required. Some of their federal and local laws that call for safeguards are the Gramm-Leach-Bliley Act, which relates to financial institutions, the Health Insurance Portability and Accountability Act, HIPAA, which relates to health records, Personal Information Protection Electronics Act, which is a Canadian law, the General Data Protection Regulation, the GDPR in Europe, and there's also one now in South Korea, Personal Information Protection Act. There's some slides, a series of slides here that talk about some of the things that can be used to help with the safeguards, tracking information, and some of the challenges as that you constantly add, remove, and update hardware and software. People, having, especially now and with remote offices, many people are using home equipment or their own devices for various things, not to mention that they've always used much of their phones. So it makes asset tracking a little more challenging. Once you have the data inventory, you want to classify the data based on risk and assign levels accordingly. This way, again, so you're not spending resources to protect assets that have less of a confidentiality nature. The chart on the screen shows it's kind of a common classification of data that you put. And it's interesting that the nature of it that personal information and some financial data of individuals becomes more confidential than some of the confidential information that is just that a business has. But it does make some sense that personal data has more weight or more risk than some things like perhaps customer lists that are able to be determined in, are kind of out in the industry anyway. The next is to manage vulnerabilities. These are weaknesses or other conditions that could be used by someone trying to get into your organization, and this relates back to, for example, Equifax that didn't do that by closing the security gap by filling it, by putting in their patches like they were for their software went in a timely manner. Again, this is controlling use of administrative procedures is another way to safeguard, and that is, making sure that passwords are protected and safe, and that the people that have access to the system are controlled and are only those that should. Security by design is a term that is used by some of the government organizations, and that is to, again, it's about tailoring the security and the way you use it to work for your organization, and to following that through to all of your systems. Some of the examples are listed in here: secure coding, least privilege access control, data segmentation, due diligence for third-party components, and that tracks through to making sure your contracts with your vendors follow through on that, using encryption when you can and when it's appropriate, separate development and production systems, so that when you're testing, you're not risking your information, code analysis and testing, and a vulnerability disclosure problem. Physical safeguards, those are the things that you would usually think of. If you have physical information, personal information, you keep it somewhere locked and monitored, and not, out on the table. Training programs, okay, training is the reference in the H.G. Wells quote before was basically to say that you do need to train as well. It's humans are often the weakest link in security, and as you realize, the attacks and all are being targeted at the humans, your employees and people that have access to the system. Dashlane is a business that's in their business is providing a password management app, and they compile an annual list of the year's worst password offenders. So I thought that was kind of interesting. For 2021, according to Dashlane, the worst offenders were SolarWinds, which I suspect many people have heard of. Although blame was likely present in many places, part of the breach through which foreign hackers were able to access internal emails at government agencies and organizations was a vulnerability in network monitoring software, and it arose through the use of, apparently the weak password was SolarWinds 123, which was leaked online. So hopefully nobody is using your organization's name and 123 as your password. The second of these worst password offenders was, it was a compilation of many breaches, and apparently an online hacking forum published more than 3 billion different passwords compiled from past breaches at Netflix, LinkedIn, Bitcoin, and others. And it revealed data of 70% of all internet users. And that is a reminder not to reuse passwords, although it's hard, I admit that. The third in the list was Verkada, and apparently a group of hackers used an administrative password which was leaked online to access more than 5,000 Verkada cameras, and it gave them views of, for example, Tesla factories and warehouses, gyms, hospitals, jails, and even some schools. So that was kind of a bad thing. The fourth one was RockU 2020. Apparently a 100 gigabyte text file with 8.4 billion passwords was posted on a user forum. The next is Facebook, which was in April of last year. A hacker leaked the phone numbers and other personal data of 533 million Facebook users. Facebook blamed the link on a vulnerability that the company had fixed in 2019. I guess it took a while to discover it. The next is Ticketmaster. Apparently, employees at Ticketmaster, I guess they thought they were being helpful, hacked into the computer system of a competitor to receive stolen passwords, costing the company a $10 million fine when it ultimately pled guilty. Next is GoDaddy. Hosting company GoDaddy revealed a breach in November that hit the accounts of more than 1 million of its WordPress customers. And that's used, a lot of businesses use WordPress for their websites. The hacker apparently used a compromised password to access the system and its legacy code for managed WordPress. The next is Act Mobile Networks, where more than 300 million personal records of VPN users were leaked. Daily QuizMe, hackers broke into a Daily QuizMe database of almost 13 million accounts for 8.3 million people, which was placed for sale on the dark web and found its way into the public domain. The New York City Law Department is the last on the list, where using one employee's stolen email account, a hacker was able to access sensitive records of the 1,000-lawyer agency, which houses information containing evidence of police misconduct, identities of children charged with crimes, medical records for plaintiffs, and personal data of city employees. The slides then set out some other items for training methods. And then we talked about vendor governance. We're getting ready to talk about that now. And then the last on that list was monitoring and review, which just means continued vigilance. Now back to the vendor contracts. This is about what type of analysis should occur in connection with vendor contracts and what provisions might be appropriate to include in the contracts. This continues with the theme of data minimization tactics. One size does not fit all. You've got to analyze each situation in a vendor contract and tailor responses to fit what's going on. For example, if a contract with a vendor doesn't include vendors' access to any personal information of individuals or, very confidential information of the business, then, the data security provisions and remedies of breach need not be as strict. It's, if there is no, if they have nothing that is a problem, then it doesn't make sense to argue about making them take risk liability. In order to do this, to start, you have to understand what services the vendor will be providing and how. Will the vendor be storing and have access to data? And if so, is it sensitive data? It is necessary to include obligations to protect sensitive data in agreements with vendors. The obligation does not go away in the hiring of a third party to provide services. You can't say, oh, but they were supposed to handle that without having required them to do that in your contract. Following through is a big part of being able to show that a business took reasonable actions and were using industry standard protection and security to get access to that affirmative defense if there is a breach. Some of the provisions to consider in a contract with a vendor or obviously the general confidentiality provision, but if it involves processing around protection and use of personal information, compliance with laws and security requirements, requiring them to perhaps have an audit, requirements to notify, the customer in the event of a breach of security. And then one step further, even if the agreement contains sufficient protection for the type of information involved, does the agreement have any teeth? What are the remedies, or is the protection somewhat illusory as there are no consequences for the vendor in failing to follow the terms of the agreement? Are the limitations on liability for the vendor such that there are no significant consequences? Not only does that leave, the business, the customer, without any real recourse for a breach, I think it could have an effect on the reasonable reasonableness of measures taken to protect the information. If you have a contract and you have all of the protective language in there, but if there's no consequences to the vendor, have you really taken reasonable measures? And the answer is, I'm not sure that you have. Some due diligence questions to ask a service provider. Does the service provider have a comprehensive and understandable cybersecurity program with planned risk assessments? And this is something that information security impact document is something that, like I said, lots of customers ask vendors for. Does the service provider have a SOC 2 report or an ISAE 3402 report? That's the international one. The SOC 2 is information security and audit by accounting firm in U.S. and the other one I mentioned is international standards on assurance engagements. If not, does the vendor have other external revisions or certifications, ISO compliance or something like that? What are the categories covered or areas addressed by the vendor's cybersecurity program? How will the data be maintained and protected? Will data be encrypted when it is rests in transit on devices? Is encryption automatic or manual? Will the service provider assume liability for breaches? That's what I was talking before. And what are the breach procedures? Is there a limitation on the vendor's liability? Will the vendor stipulate to permitted uses and restrictions on data use? Will it educate its personnel on such limits? What are the vendor's procedures for notifying in the event of a breach of the vendor system? Are the procedures satisfactory and are they timely? Will the vendor provide regular reports on its security risk analysis results and updates and management procedures? Again, some of these questions only apply depending on what information the vendor is going to have of the business, of the customers. What are the vendor's training requirements for its personnel? Does the vendor have cybersecurity or other insurance coverage, and what kind is that? Many of these vendor contracts will have an insurance provision and require that, and also if it's large enough, you might be able to get listed as an additional insured. And does the vendor use subcontractors? Make sure that the vendor's subcontractors must comply with the agreement and that the vendor is responsible if they don't. And then you can go further to if it is very sensitive data, especially if it involves health information, have there been background or reference checks on the vendor's employees and those kind of things. Let's see. I think we're getting to the end of the presentation now. I will take questions after a few housekeeping announcements. As mentioned in the beginning, this session has been recorded and will be posted on the firm's YouTube channel. The recording will be turned off now prior to taking any questions. Also remember that you will receive an email from Renee Lamb that will have the activity numbers to claim CLE credit from Kentucky and Indiana. The email will have a link to a survey and please fill it out. We use the survey to make improvements. Also, please let us know, and there's a question in the survey, if there are topics that you would like to hear about in the future, and stay tuned for announcement in the near future of our next SKO U CLE presentation. And you can ask questions in the chat box if you have any.